The Portuguese Labour Code prohibits the practice of harassment and provides for a definition of both moral and sexual harassment. The first is an unwanted behavior which is carried out during access to employment or during employment and has the purpose or effect of upsetting or embarrassing the person, affecting the dignity or creating an hostile, demeaning or humiliating environment. Sexual harassment is the unwanted behavior of sexual nature, either verbal, non-verbal or physical, with the same aim or effect on the victim. Stress arising from the normal performance of the functions is excluded from this definition.
The law in Australia recognises that sexual harassment can happen in two legally defined ways. The first is what we commonly refer to as quid pro quo harassment. And quid pro quo harassment occurs where one person makes an unwelcome sexual advance towards another person, and both of those individuals are workplace participants. The second type of sexual harassment under Australian law is what we commonly refer to as hostile work environment harassment. And hostile work environment harassment recognises that even if a person has not made an unwelcome sexual advance towards another person, they have still engaged in other unwelcome conduct of a sexual nature in circumstances in which a reasonable person would look at that behaviour and understand that the person being harassed would have felt offended, humiliated or intimidated by the conduct involved. So under Australian law, there are those two legal definitions, both sitting under the heading of what constitutes sexual harassment. On the question of whether you can have top-down sexual harassment under Australian law, in other words, can you have a situation where the manager feels that they have been sexually harassed by someone who may be working for them? The short answer is yes. Under Australian law, there does not have to be any power imbalance in order for the legal definition of sexual harassment to be met. The only thing that needs to be satisfied is that the sexual harassment legal definition, whether that's quid pro quo harassment or hostile work environment harassment, has actually been met, and that the two people or the people involved are workplace participants. So there is nothing to say that it can only be unlawful sexual harassment where there is someone more senior as opposed to someone junior who is engaging in that conduct that amounts to sexual harassment.
Yes, under the Portuguese Labour Code, moral harassment at work can also be experienced horizontally, co-workers of the same hierarchical rank, as well as, although less frequently, bottom-up harassment in cases where subordinates riot and terrorize a superior, usually using acts of sabotage of the superior's work. In such situations, the employer's responsibility is not excluded, meaning that harassment can be reported to the employer, making it responsible for initiating the disciplinary proceeding.
Harassment, specifically sexual harassment, is a hot topic of conversation currently in the UK. This is because, as of the 26th of October this year, all employers have a mandatory duty to take reasonable steps to prevent sexual harassment in the workplace. It's a preventative duty, and employers will need to anticipate scenarios where sexual misconduct might occur and take reasonable steps to prevent sexual harassment by an employee or by a third party. As part of an investigation into harassment, the burden of proof is the civil standard. Investigators are required to determine the facts of a matter on the balance of probabilities. There is no one-size-fits-all when it comes to an investigation. However, they should be robust and undertaken fairly and with independence and integrity. Particular care should be given as to who is appropriate to act as the investigator and whether they can reach conclusions impartially. Complainants, the accused and witnesses should all have an opportunity to present relevant evidence to the investigator, who should approach fact-finding with an open mind and then report their findings within a considered written report.
In terms of what are the obligations that an employer has to deal with sexual harassment, this has been an area which has seen a considerable amount of additional activity under Australian law in recent years. Around 2 years ago, the law was changed so that employers in Australia now have what is referred to as a positive duty to eliminate hostile work environment harassment from taking place. And if an employer has not discharged that particular duty, then that employer is in breach of its obligations under Australian legislation. This is different to the defence that an employer might seek to establish if they are being sued by an employee, for example, for sexual harassment. Now, in a civil claim, an employer will be liable unless the employer can show that it took reasonable steps to prevent that harassment from occurring. The positive duty sits separate to the reasonable steps that an employer is required to take, but naturally there is some overlap between those two concepts.
Employers can be held accountable when one employee harasses another employee in the circumstances where employer fails to take any preventative measures in accordance with its new duty. For example, when it fails to implement policies or procedures in place that deal with harassment, and also fails to train its staff on the new policies and procedures, so staff simply is not aware what they're supposed and not supposed to do in relation to harassment. Employer can also be held accountable when it simply fails to investigate, complain, or even protect the victim of sexual harassment. In terms of harassment by third parties, so similar considerations will apply to the employer, but employer will also be expected to take risk assessment, preferably in consultation with employees so that they know what needs to be implemented and take those reasonable steps that is required. And also what is expected from the employer is to warn the third parties, which could be customers, clients, well, pretty much anyone who is not an employee, that sexual harassment will not be tolerated, and implement those policies in place.
For the harassment to be a reason for the dismissal of the accused employee, there must be a guilty, serious and illicit conduct of the employee, either in itself or due to its consequences, that leads to the practical and immediate impossibility of maintaining the labor relationship.